Evan Bernick is with us. We always appreciate the professor's time. Evan Bernick here to...
Morning, Steve.
Good morning to you. Thanks for coming on again.
Absolutely. Always a pleasure.
Assistant professor on IU College of Law. Donald Trump has a hearing at the Supreme Court today. Tell us more.
Yeah, so the D.C. Circuit, to really nobody's surprise, held that the president is not immune from criminal liability for acts while in office. He can be prosecuted after he leaves office for any alleged crimes, and these crimes are alleged in the context of the January 6th insurrection. Not surprising. The only thing that was slightly surprising is that it took so long, and now we have a few answers as to why. The court really took its time to craft a very well-reasoned and lengthy 57-page opinion. A panel consisting of two Democratic appointees and one Republican appointee who takes a very broad view of presidential power held that the president's claims are baseless. And so now the only question is whether the Supreme Court will take a different view.
We don't know if they'll take that case, right? We don't know, based on the appeals court decision, if there's anything there for the court to decide, or yes, they will take it. Where are we?
So the D.C. Circuit has done its best to craft an opinion that gives the Supreme Court an easy out. This is a unanimous court that says, in the context of a claim that really hasn't been raised before by anyone, this claim is baseless. And the Supreme Court could just say, it's not worth our time. It is that clear. It's the equivalent of a 19-year-old arguing that, notwithstanding the constitutional text, I'm capable of becoming president, even though the Constitution says I've got to be 35 years old. The court's not going to take that case either.
Now, isn't it important for the Supreme Court to come out with their verdict before March 5th because of the Colorado primary? And will they do that?
So we want to disentangle two different cases. There's one case involving whether the 14th Amendment excludes Trump from the ballot. The other case is whether the president is immune from criminal prosecution. So those are two separate issues that are running on different tracks. The Supreme Court has decided to take the Section 3 case. It could decide not to take the other case at all, or it could decide to take it. I predict that it won't take it.
Where is the likelihood of this going to fall? Look, regardless of how I feel about Trump or anybody feels about Trump in the positive or the negative side, Trump being on ballots that he's earned his way on seems like that's the way the thing was designed. Is that too simplistic?
I think what people who take the opposite view are saying is that democracy is great, but it's also structured by the Constitution. And the Constitution has a Section 3 of a 14th Amendment. And Section 3 of the 14th Amendment says that if you, having taken an oath of office and holding office under the United States, engage in insurrection or rebellion, you can't hold office again. And the argument is that Trump satisfies those criteria. And this issue is more hotly contested than the presidential immunity issue. And I suspect that when the court takes it up, it's going to be, now that the court has taken it up, it's going to be a closer case. I can see some justices taking the view that Trump is not automatically excluded from the ballot. If Congress wants to exercise its 14th Amendment powers and say the president or the former president engaged in insurrection and isn't eligible, that's one thing, but states can't unilaterally do it.
Yeah, and my confusion here, I suppose, lies in this basic premise, and the premise being if he hasn't officially been tried on the insurrection, tried and found to be complicit, guilty or not, then isn't it more of an opinion-based decision the court would make?
So the Section 3 of the 14th Amendment doesn't require that anybody be found guilty in a criminal court of law. It imposes a penalty that's very different from imprisonment. It says you're not eligible for office again. So the due process, all the stuff that we, associate with the rule of law, that says that, you're innocent until proven guilty, that has relevance in a criminal prosecution. But Section 3 doesn't criminally punish you. It just says you're not eligible for office. That being said, the standard that the court applies to determine whether somebody is engaged in rebellion or insurrection, that's very unsettled. And the question of whether the Section 3 even applies to the president at all, there's some dispute about that, is an unsettled question. And that's what makes it a more complex case than the presidential immunity thing is kind of sexy, but it's really not going anywhere.
So if the Section 3 does apply, doesn't that then overtake the local case?
The Colorado stuff and the state's case?
Yeah.
Right. So if Section 3 applies to the president, and if the president satisfies the criteria of Section 3 that he engaged in rebellion or insurrection, everybody's hands everywhere in the nation are tied. They've got to exclude him from their ballots. Everybody, even the most lowly official, has to do their part to prevent that from happening. It's self-executing. That's how we refer to Section 3. It doesn't require anybody to act, on one view. On another view, Section 3 is for Congress to enforce. And unless Congress singles the president out and says he engaged in insurrection and rebellion, then he's got to appear on the ballots.
Congress can't enforce that today is Wednesday. So if it's left to Congress, nothing will happen.
Right,
or today being
idea.
Thursday.
And
that's why Congress can't enforce it. No, today is Thursday, yes.
Right. So everybody knows that Congress is not going to do this. So if Section 3 is not self-executing, that is, if the president is not just in virtue of the operation of the text without Congress's action required to be excluded from ballots, nobody's going to do anything. And that's why the stakes of this, the determination of whether Section 3 is self-executing, to say nothing of whether it applies to the president in the first place, is so high.
When the Supreme Court makes a decision, opinions are assigned and handed out or requested and written, and we find out sometime later. In a case like this, do we find out quickly?
It's just really hard to predict how quickly or how slowly the Supreme Court does anything. It has basically blanket discretion to set its own timeline and do its own thing. And Chief Justice Roberts will exercise whatever power he has to make sure that the court weighs in at precisely what he regards to be as the right moment.
So, let's go on this, Evan Bernick. This came up with a friend of mine yesterday. Do we know how cases are chosen? Is this a law class that I missed since I'm not a lawyer? The Chief Justice doesn't just in a show of force say we're taking this case, we're not taking that case. But I also don't think they, order out for potbellies and then the 9 of them vote. So how do we know which course? Who determines which cases are taken and not taken?
So there's a rule of 4. If 4 justices want to hear a case, then the case gets heard, and the people who want the Supreme Court to hear cases petition for what's called a writ of certiorari. And in order for a writ of certiorari to get granted in the court to hear the case, you need 4 justices. That being said, there's all sorts of speculation about what goes on behind the scenes concerning how we get to 4 or we don't get to 4. You don't have the Supreme Court deciding to, unilateral or to take a case on the initiative of just one justice with some kooky idea. But, to the extent that Chief Justice Roberts has a particular desire that something be taken up or not, that probably carries more weight than a more junior colleague.
So there's no rock, paper, scissors involved as far as we know?
There should be.
Not to my knowledge.
Right.
It works.
Great stuff as always. Evan Bernick, Assistant Professor, NIU College of Law. Thank you for the education.
Thank you, Evan.
Absolutely, Steve. Great talking with you.
All right, be well. What do you think? Could we get an A in that class?
No.